going to talk about disclosures today. So in 1993, an act was written and went into effect on January 10th of 1994. It was called the Seller's Disclosure Act. It is a standardized form required by law that's filled out by the seller. It requires the seller to disclose a property's physical condition and to make known any material defects. So, unless you are required to study real estate law like I am, that is not exactly what you wanted to know. In layman's terms, the information given will help a buyer to make an informed decision as to whether to purchase that home and on what terms. It's an important document that sellers must comply with. Failure to comply with that seller's disclosure will make a buyer be able to cancel the sale, and the seller could be sued for fraud if defects that a seller knew about were not disclosed, and that can be proven. There are a few instances that do not require disclosure. Transfers by a court order, like probate, guardianship, conservatorship. If the bank is taking over the house in foreclosure, they know nothing about the property, they do not have to disclose. It'll just say across the top of it that they never lived in the home, or they're exempt. A trustee in a bankruptcy is another one. Transfer by eminent domain. Eminent domain is when property is seized for the betterment of the greater community. Like the Gordie Howe Bridge, they came and took 12 or 15, 20 houses, whatever, and they took them for eminent domain. You don't have to transfer between co-tenants or a spouse, a parent, a grandchild, a grandparent. There's no transfer of disclosures between spouses in divorce. They obviously know what's going on in the house. Transfers from a government entity is not required. Transfers for newly constructed property, the builder usually takes care of that. In Michigan, sellers do not have to disclose whether a property is stigmatized by death, murder, or infectious disease. I know people think so, but you don't have to do that. I like to bring them to showings. When I go to showings, I always take the disclosures ahead of time. I usually take them to open houses so that they can get stuff early in the process and they can see what's going on in the house. Another type of residential sale disclosure is a lead-based paint disclosure. Home buyers and renters should be given a lead-based paint disclosure. If a home was built prior to 1978, there is a good chance that there's lead paint in that home. To abate the paint, you paint over it or seal over it. But shipping paint and any surface that may rub, like windows and doors, can cause lead dust. So that could be a potential hazard. There is an EPA pamphlet called Protect Your Family from Lead in Your Home that is given to every buyer or renter, or should be given to every buyer or renter. Buyers are given the right to a 10-day period to conduct a risk assessment for lead-based paint hazards. You can waive the assessment on the disclosure, or you can get it assessed by an inspector who's certified to do so. Make sure he's certified in lead paint. If a home was built after 1978, I have the sellers fill out the disclosure anyway and to sign it appropriately. It's important to take these disclosures seriously and fill them out clearly and truthfully. It's the right thing to do, and it is the law.